So, public interest litigation PIL. Let's see for what is this PIL in detail. The concept of the PIL, public interest litigation, originated and developed in USA in 1960s. In the USA, it was designed to provide the legal representations to the previously unrepresented groups or interests. Unrepresented groups and interest, which means that significant segments of the population and a significant interest. Such group and people include the poor, environmentalists, consumers, radicals, and ethnic minorities and others. In India, the PIL is product of the judiciary activism. As we already discussed, our role of the Supreme Court. It was introduced in the early 1980s. Justice Krishna Iyer and Justice P.N. Bhagwati were the pioneer of the concept of PIL. PIL is also known variously as a social action litigation, social interest litigation, and class action litigation. Meaning of PIL is the introduction. Meaning of PIL. The introduction of PIL in India was facilitated by the relaxation of the traditional rule of locus standi. According to this rule, only that person whose rights are infringed alone can move the court for remedies, whereas the PIL is an exception to this traditional rule. Under the PIL, any public spirited citizen or the social organization can move the court for the enforcement of the rights of any persons or group of persons who because of their poverty or ignorance or socially or economically disadvantaged positions are themselves unable to approach the court for the remedies. Thus, in a PIL, any member of the public having sufficient interest can approach the court for enforcing the rights of other persons and redressals of the common grievances. Supreme Court has defined the PIL as a legal action initiated in a court of law for the enforcement of the public interest or general interest in which the public or the class of community have pecuniary interest or some interest by which the legal rights or liabilities are affected. PIL is absolutely necessary for maintaining the rule of law, furthering the cause of justice and accelerating the pace of realizations of the constitutional objectives. In other words, the real purpose of PIL are vindications of the rule of law. Second, facilitating effective access to justice to the socially and economically weaker sections of the society. And third, meaningful realizations of the fundamental rights. Now let's see what are the features of the PIL. The various features of the PIL are explained. Number one, PIL is a strategic arm of legal aid movement and is intended to bring justice within the reach of poor masses who constitute the low visibility area of humanity. Number two, PIL is a totally different kind of litigation from the ordinary traditional litigation, which is essentially of an adversary character where there is a dispute between the two litigating parties, one making claim seeking relief against the other and that other opposing such claim or resisting such relief. Next, number three, PIL is brought before the court not for the purpose of enforcing the rights of one individual against other, as happens in the case of ordinary litigations, but it is intended to promote and vindicate public interest. Number four, PIL demands that violations of the constitutional and legal rights of large numbers of people who are poor, ignorant, or in a socially or economically disadvantaged position should not go unnoticed and unaddressed. Number five, PIL is essentially a cooperative effort on a part of petitioner, the state or public authority, and the court to secure observance of the constitutional or the legal rights, benefits and privileges conferred upon the vulnerable sections of the community and to reach social justice to them. Number six, In PIL, litigation is undertaken for the purpose of redressing public injury, enforcing public duty, protect social, collective, diffuse rights and interests, or vindicating public interests. Number 7. In PIL, the role held by the court is more assertive than in traditional actions. It is creative rather than a passive, and it assumes a more positive attitude in determining acts. Though in PIL, court enjoys a degree of flexibility unknown to a trial of traditional private law litigations. Whatever the procedure adopted by the court, it must be procedure known to judicial tenets and characteristics of the judicial proceedings. In a PIL, unlike traditional disputes resolutions mechanism, there is no determination on adjudication of individual rights. Now let's see the scope of PIL. In 1988, the Supreme Court formulated a set of guidelines to be followed for entertaining letters or petitioner received by it as PIL. These guidelines were modified in 1993 and 2003. According to them, the letters or petitions falling under the following categories alone will be entertained as PIL. Number 1, bonded labor matter, neglected children, non-payment or minimum wage to worker, and exploitations of casual worker, and complaints of violations of the labor laws, except in individual cases. Petitions from jails complaining of harassments for premature release and seeking release after having completed 14 years in jail, death in jail, transfer release or personal bond, speed trial as a fundamental right. Petitions against police for refusing to register a case, harassment by police, and death in police custody. Petitions against atrocities on women, in particular harassments of bride burning, rape, murder, kidnapping, etc. Petition complaining of harassments of torture or village by co-villagers or by police from person belonging to scheduled caste or scheduled tribe and economically backward classes. Petition pertaining to environmental pollution, disturbance or ecological balance, drugs, food adulterations, maintenance of heritage and culture, antiquity, forest and wildlife, and other matters of public importance. Petitions from riot victims, family pensions. The cases falling under the following category will not be entertained as PIL. Number 1, landlord-tenant matters, service matter, and those pertaining to pension and gratitude, complaints against central or state government, departmental and local bodies, except those relating to items number 1 to 10, as we discussed previously. Admission to medical and other educational institution. Petitions for early hearing of case pending in high courts and subordinate courts. Now let's see the principles of PIL. Supreme Court evolved the following principles in regards to PIL. Number 1, the court in exercise of power under the Article 32 and 226 of the Constitution can entertain a petition filed by an interested person in the welfare of the people who are in disadvantaged positions and thus not in a position to knock the doors of the court. The court is constitutionally bound to protect the fundamental rights of such disadvantaged people and direct the state to fulfill its constitutional promises. When the issue of public importance enforcements of the fundamental rights of large number of people vis-a-vis the constitutional duties and the functions of the state are raised, the court treat a letter or the telegram as a PIL. In such cases, the court relaxes the procedural laws and also the law relating to pleading. Whenever injustice is meted out to a large number of people, the court will not hesitate to step in to invoke Article 14 to 21 of the Constitution of India, as well as the International Conventions on Human Rights, which provides for a reasonable and fair trial. Next, the common rule of locus standi is relaxed so as to enable the court to look into the grievances complained on behalf of the poor, deprived, illiterate, and the disabled who cannot vindicate the legal wrong or legal injury caused to them for violations of any constitutional or legal rights. Next, when the court is prima facie satisfied about the violations of constitutional right of a group of people belonging to the disadvantaged category, it may not allow the state or the government from raising the question as to the maintainability of the petition. Next, although procedural law apply in PL cases, the question as to whether the principle of res judicata or principles analogous thereto would apply depend on the nature of the petitions and also fact and circumstances of the case. The dispute between two varying groups purely in the realm of private law would not be allowed to agitate as a PIL. Next, however, in an appropriate case, although the petitioners might have moved a court in his private interest for redressal of the personal grievances, court in furtherance of the public interest may treat it necessary to inquire into the state of affair of the subject of litigations in the interest of justice. Next, the court in special situations may appoint commissions or other bodies for the purpose of investigating into the allegations and findings out facts. It may also direct management of public institutions taken over by such commission. Next, the court will not ordinarily transgress into a policy. It shall also take utmost care not to transgress into jurisdictions while purporting to protect the rights of the people from being violated. The court would ordinarily not step out of known areas of judicial review. The High Court, although may pass an order for doing complete justice to the parties, it does not have a power akin to Article 142 of the Constitution of India. Ordinarily, the High Court should not entertain a writ petitions by way of PL requests questioning constitutionality or validity of the statute or the statutory rule.